this meeting of the Open Caucus. I'm Art Eggleton, Senator from Toronto, and beside me is Senator Raymond Saint-Germain, who is Senator from Quebec, and we will co-chair today's meeting. And the Open Caucus is a forum for discussion on issues of national importance, and this meeting is co-sponsored by the Independent Senators Group, or ISG, and the Independent Senate Liberals, all independents. This non-partisan discussion is open to all members of Parliament, senators, parliamentary staff, media, and the public who are in front of me. Now today, our discussion focuses on the North American Free Trade Agreement. When NAFTA entered into force in January 1994, it established one of the largest trade blocs in the world. NAFTA created a highly integrated system amongst the three member states. In 2015, the total trilateral merchandise trade amounted to over US $1 trillion. Now, of course, we all know about recent times. The President of the United States, Donald Trump, has raised his concerns about NAFTA and demanded a renegotiation. Or he'll tear it up. We're still waiting. Although a lot of uncertainty prevails, and drama, of course, as well, there's also the opportunity here to update an agreement and align it with current realities. For instance, the new agreement can address e-commerce, as NAFTA was established before the digital age. With the current negotiations underway, it's important that Canadians, including parliamentarians, are informed of the challenges and rewards that will come with a modernized agreement. A new agreement needs to address a wide range of issues cutting across many sectors. Canada's main demands include, for example, new chapters on labor standards, gender rights, environmental standards, and Indigenous rights, reforms to the investor-state dispute settlement process, expanded procurement, the freer movement of professionals, the protection of Canada's supply management system for dairy and poultry, protect cultural exemptions, and maintaining a process to regulate anti-dumping and countervailing disputes. So considering the complexities involved in renegotiating this expansive trade agreement, we ask the questions: how will a modernized NAFTA impact Canadians and Canada's relationship with our North American partners, if indeed we do get a modernized NAFTA? So that sets the stage for our discussion this morning. In terms of a couple of logistics, let me point out that coffee is available, and tea, I think, at the back of the room. For those in the audience, translation, I mean, everybody at the table of senators all know how the translation system works, but for those at the back, the headsets are located at your chair. Channel 13 is for English, and channel 14 is for French. Now, we encourage audience participation. So, as we go through the meeting, particularly into the latter part of the meeting, we will give an opportunity for anybody who's sitting in front of me who wants to get up for up to 3 minutes, make a point, ask a question. There's microphone number 5 that is in place for that purpose. But the person you have to let know, so I get to know, is Agnes. Where's Agnes? There's Agnes. So you just tell Agnes that you want to say something, and also indicate if you're from any particular organization or academic institution, let us know which one that is. So those are the logistics. So now I'll ask my co-chair, Senator Raymond Saint-Germain, en français.
Merci, Monsieur le sénateur et coprésident. Je ne répéterai pas tout ce qui a été dit par mon collègue, qui a été fort bien dit d'ailleurs. Souhaiter quand même la bienvenue aux collègues sénateurs, aux gens qu'on accueille avec plaisir de l'auditoire et bien sûr à nos invités. Simplement ajouter sur le thème à ce qu'a dit le sénateur Eggleton. Ce qui est intéressant, c'est que notre thème a bien sûr été choisi il y a quelques semaines déjà. Et Encore aujourd'hui, l'actualité foisonne de nouveaux développements sur les enjeux de commerce entre le Canada et les États-Unis et le Mexique. Nous avons en effet appris dernièrement que les négociateurs américains ont réclamé l'abolition de notre système de gestion de l'offre pour le lait, pour les œufs, pour la volaille. Et cela s'ajoute à d'autres demandes ambitieuses de nos voisins du Sud, comme le resserrement des normes d'origine dans le secteur automobile et l'affaiblissement des mécanismes de règlement des différends. Nous savons très bien que les négociations actuelles ont pour trame de fond plaintes, enquêtes et poursuites de nature commerciale, entendues devant différentes instances, et que les discours protectionnistes captent l'attention du public. La conjoncture politique actuelle avec les élections générales mexicaines et celle de mi-mandat aux États-Unis en 2018 ajoute à la tension et à la complexité des négociations en cours. Bien que plus que jamais, le Canada cherche à diversifier ses partenaires commerciaux, comme en font foi nos espoirs avec les pourparlers qu'on entreprend avec les pays sud-américains et les pays asiatiques, l'ALENA demeure et va demeurer un pilier de notre économie. Alors, je vais céder sans plus tarder la parole à nos panélistes, en commençant par Michael Geist, que je vais brièvement vous présenter. Michael est professeur de droit à l'Université d'Ottawa et détenteur de la chaire de recherche du Canada en droit d'Internet et du commerce électronique. Il est également membre du Centre de recherche en droit, technologie et société. Il est l'éditeur de plusieurs livres sur le droit d'auteur et rédacteur en chef de plusieurs publications mensuelles concernant le droit et les technologies. Il est également l'auteur d'un blog très fréquenté sur les questions liées à l'Internet et à la propriété intellectuelle. M. Geist est également membre de différents conseils, notamment ceux de l'Autorité canadienne pour les enregistrements d'Internet et d'Internet Archive Canada, ainsi que le Conseil consultatif d'Electronic Frontier Foundation. En 2010, Managing Intellectual Property le désignait comme l'une des 50 personnalités les plus influentes du domaine de la propriété intellectuelle dans le monde, et Canadian Lawyer l'a nommé parmi les 25 avocats les plus influents au Canada. Inutile de vous dire que nous avons été très heureux qu'ils répondent oui à notre invitation. Alors, Monsieur Professeur Guest, la parole est à vous.
Great, thank you very much. Good morning, and thanks so much for the invitation. As you heard, my name is Michael Geist. I'm a law professor at the University of Ottawa, where I hold the Canada Research Chair in Internet and E-commerce law. I appear today in a personal capacity, representing only my own views. Now, in light of yesterday's events, it may be hard to focus on NAFTA's intellectual property and e-commerce chapters. It goes without saying that the minister has identified other issues that are bigger sources of contention. However, precisely because there are other issues that are demanding attention, there is a risk that important IP and e-commerce issues may be overlooked to the detriment of Canadian policy. I'd like to focus on 3 points with these opening remarks. First, on meeting international standards. While modern trade agreements typically feature IP chapters, e-commerce chapters are at this stage still pretty unusual. Significant reforms are invariably best left to domestic policy processes. Canada has a strong record of innovative IP and e-commerce rules. We've got some of the toughest anti-piracy laws in the world, with declining piracy rates, strong e-commerce and privacy laws, and some unique balancing provisions in our copyright rules. These frameworks are the result of extensive domestic consultations and crafting of laws that reflect Canadian priorities. Within a trade negotiation context, many of those priorities can easily be lost amidst a myriad of other issues. The reports on rules of origin, dispute settlement, supply management that we just heard about point to a challenging and somewhat contentious negotiation, and it suggests that IP and e-commerce might get lost in the noise. The solution, I would argue, is relatively straightforward. NAFTA should require each party to meet international standards as found in global agreements on IP and e-commerce. It is reasonable to expect all parties to meet international standards. It is not reasonable nor advisable to undertake significant domestic change on those issues through secretive trade negotiations that feature limited consultation and can dangerously distort traditional efforts at balance. Secondly, do no harm. We can assume that the U.S. wants more than just harmonization on intellectual property and e-commerce. Rather, it will push for Americanization of those rules. Canada should resist changes that can harm our domestic market and undermine a made-in-Canada approach. For example, there have been recent calls for North America-wide website blocking and the full criminalization of copyright. These proposals have been widely criticized, but point to the harm that trade agreement provisions can create. Similarly, the U.S. is likely to seek an extension in the term of copyright that goes beyond international law requirements. The term of copyright in Canada today is presently life of the author plus an additional 50 years after their death, a term that's compliant with the international standards set in the Berne Convention. I recently conducted research on the role of copyright term and the public domain in Canadian schools using data obtained by the Ontario Book Publishers Organization. According to data from hundreds of school teachers and school districts, half of the most popular books taught in grades 7 through 12 are in the public domain or about to enter into it. If we extend the term of copyright under U.S. pressure, dozens of books used by thousands of students today across the country that are scheduled to enter into the public domain would be shut out for decades. The prospect of using those books in new and innovative ways without the need for further licensing and royalties, as well as increasing access in open electronic form, as we're seeing in many provinces, would be lost for a generation. The e-commerce chapter also raises risks of harm. For example, Canada should be wary of provisions that undermine legitimate public policy objectives, particularly on privacy and security. The U.S. has identified blocking restrictions against what's local data storage requirements, something often referred to as data localization, as one of its objectives. The idea there is that a country would be stopped from maintaining that data must be retained within their borders, within their country. Canada should resist efforts within NAFTA to limit the ability of the federal provincial governments to establish legitimate privacy and security safeguards through those data localization requirements, and there are a couple of provinces that have already established them. Limitations on data transfer restrictions, which mandate the free flow of information on networks across borders, can raise similar concerns. While the U.S. is seeking a ban on data transfer restrictions, Canada should ensure that privacy and security laws will not be superseded by NAFTA restrictions, as it runs the risk of losing sovereignty over privacy policy and could place us between a proverbial rock and a hard place, with the European Union requiring restrictions and the U.S. trying to ban them through NAFTA. Thirdly, a level playing field. If Canada were to adopt a more proactive approach on intellectual property and e-commerce, our focus should be on ensuring that there is a level playing field for innovative businesses and creators. Now, what might that look like? I'd like to raise 5 possibilities. First, Canada should insist on the inclusion of language on maintaining balance across all intellectual property rights, the legitimate interests of users, promoting access to and preserving the public domain, ensuring that IP rights don't create barriers to legitimate trade, and facilitating access to affordable medicines. Similar language was raised in the Trans-Pacific Partnership, and it belongs in NAFTA. Second, the availability of what's known as fair use in copyright is available in the United States, and it represents a significant competitive advantage for U.S. businesses and creators because we don't have the same provision in Canada. To ensure a level playing field for innovation, the NAFTA IP chapter should require that all countries feature a fair use provision or fair use equivalent provision. Thirdly, Canada's anti-circumvention provisions, often referred to as digital lock rules, are amongst the most restrictive in the world, creating unnecessary restrictions on innovation. The Canadian exceptions that were established in 2012 were very narrowly constructed and limited to a handful of circumstances under U.S. pressure. In fact, the United States today has been expanding the number of exceptions that they have so that there is now an imbalance, an unlevel playing field where the U.S. has more flexibility for innovation, Canada suffers without it. Fourth, the NAFTA IP chapter should also address the abuse of intellectual property rights that can inhibit companies from innovating or discourage Canadians from taking advantage of the digital market. And we've seen many stories of Canadian businesses suffer, particularly where they face lawsuits in the United States under some of their IP rules. The benefits of an anti-IP abuse law could be used to touch on patents, trademarks, and copyright. Fifth, Canada has established strong privacy and anti-spam rules. If anything, it's the United States that is out of step with international standards on those issues. We ought to be seeking better privacy protections to level the playing field for both businesses and consumers. In conclusion, there are opportunities for Canada to advance its interests in the IP and e-commerce chapter in NAFTA. I believe it starts by emphasizing international standards, rejecting some of the harmful proposals that we've started to see floated, and focusing on creating a level playing field throughout the North American market for IP and e-commerce. I look forward to the discussion and your questions.
Thank you very much, Professor Geist. You've presented quite a few very valuable thoughts on the whole question of e-commerce and intellectual property, and I wonder if we can have a copy of your presentation and follow up on that from here. Our next panelist is Al Mussel. He's the founder and research lead of Agri-Food Economic Systems Incorporated. His areas of research expertise are farm management, agricultural marketing, agricultural policy. He has worked as an economist in the milk procurement division of Land O'Lakes Incorporated in Minnesota. He holds a Master of Science degree in agriculture economics from the University of Guelph and a doctorate in agricultural economics from the University of Minnesota, where he was a Fulbright scholar. He is past president of the Canadian Agricultural Economic Society, a past director of the Progressive Dairy Operators, and an alumnus of the U.S. State Department International Visitor Leadership Program. So he's got both sides of the border on this issue. His understanding is very valuable in this context. Dr. Mussel.
Madam Chair, Mr. Chair, members of the Senate, ladies and gentlemen, thank you for the opportunity to speak with you today. My remarks will deal with trade in agricultural and food products, an area in which I work as a researcher. This is a timely discussion, with Canada actively engaged in negotiations with the U.S. and Mexico on renewal of NAFTA, the CETA agreement with the EU just coming into force, Canada among the lead advocates of a Trans-Pacific Partnership 11 trade agreement, and Canada engaged in trade negotiations with India and in discussions exploring trade negotiations with China. Trade and export market access are fundamental to Canadian agri-food. Canada's extensive agricultural production capacity exceeds the food demand of Canadians, and in order to fully use its endowment of resources, Canada's farm and food outputs need export markets. Moreover, Canada's system of managing the purity and integrity of products it produces is among the finest in the world, and its exports are sought out and counted on in providing a food supply to other countries. Agri-food exports are a major element of economic development, especially in rural areas lacking the breadth of opportunity of large urban areas. According to the Canadian Agri-Food Trade Alliance, Canada is globally the 5th largest agri-food exporter, and in 2016, Canadian agri-food exports were worth $56 billion, with approximately half of the Canadian agri-food output exported. At the same time, as a northern country with an affluent and cosmopolitan population and diverse tastes and preferences, Canadian demands for food extend beyond the breadth and depth of products that we can produce efficiently here. Agri-food imports provide Canadians with food products that cannot be produced efficiently here and cater to the diversity that is Canada. Equally, food products that are produced here can be enhanced by foods, ingredients, and seasonings obtained from elsewhere. Put differently, if the diversity of Canadian food demands had to be supplied solely from domestic production, we would need to dramatically reorient ourselves away from some of the products in which we are world leaders and operate on an export scale, and toward other products less suited to our climate and in which we are far less efficient. This would end up creating great inefficiencies and costs. People and resources would be pulled away from other economic sectors and into agriculture and food processing, and Canada would be a less wealthy and prosperous country. Thus, the Canadian agenda in agri-food is not mercantilist. Canada requires export market access for many of its products, secure and efficient access to imports for others, and a trade environment in which the domestic regulation of specific markets can occur effectively. At the same time, trade is embedded with many other aspects of Canadian agriculture and food. Operating in a northern climate, Canada faces the challenge of sustaining competitive productivity versus other regions. Canada's unique agricultural productivity challenges must be engaged with ongoing research and development conducted by both the public and private sectors. Consumers of Canadian products are increasingly concerned with the environmental footprint of agriculture. Mitigation and environmental improvement achieved through research and refined practices must be integrated into products and processes just to maintain market access, as well as deepen social license and advance broader societal goals. New and emerging platforms for food distribution and marketing will challenge the traditional role of natural borders, just as e-commerce and packaged goods has. This could shift the competitive dynamic facing Canadian agri-food, and food marketing systems will need to adjust accordingly. Agri-food trade negotiations can often be quite contentious among our trading partners as well as among voices in Canada. This relates to the fact that changes in trade rules can end up influencing economic development in rural areas where agriculture occurs, with the prospect of associated social disruption and environmental impact. It is the job of negotiators, researchers, policy analysts, industry, and public leaders, such as members of the House and Senate, to assess the opportunities and efficiency benefits of liberalized trade, to find consensus, and to deal appropriately with those disadvantaged by liberalized trade. While other trade agreement discussions are underway, the issue of the day is NAFTA renegotiation. Because trade among Canada, the U.S., and Mexico is already largely tariff-free in agri-food, the key issues for Canada are technical regulatory issues and issues related to products that are supply and managed in Canada: dairy, poultry, and eggs. The issues that I describe as technical in agriculture and food are generally well known and have been the source of past effort among NAFTA partners. In particular, Canada and the U.S. established a Regulatory Cooperation Council to deal with the broad issue of differences in regulatory standards and processes. Progress has occurred in many of these issues in agri-food, such as the harmonization of pesticide maximum residue levels, harmonization of agricultural chemical regulatory approvals, the standardization of meat nomenclature, and a range of others. Other issues relate to border disparities, such as the grading discounts applied to American grain delivered to Canadian grain elevators and the extra costs of redundant inspection of Canadian meat exports at the U.S. border. These are matters of common interest in the NAFTA negotiations, with no strongly held opposition evident so far by any of the NAFTA parties. While failure to reach agreement on these technical issues would embolden serious inefficiencies, progress on these is ongoing. For example, a joint Canada-U.S. food safety risk assessment organization has been proposed as an element of NAFTA renegotiation, the subject of a conference to be held in Washington later this month. Canadian dairy policy is not a matter of common interest. It has been raised as an irritant by the United States. However, it is poorly understood. The established U.S. agenda has been to pressure for increased access into the Canadian market for dairy products. In the past, the U.S. has not seen it as in its interest to destroy supply management. Canada's agenda has been to retain supply management as a marketing mechanism to control farm product surpluses and to provide positive returns to producers. And this has evolved substantially over time with changes in technology, market, and policy factors. Supply management is a construct of both federal and provincial governments, with the federal government in charge of border controls that protect supply managed products, but with most of the pricing and production quota aspects, as well as the bulk of the actual administration of supply management, carried out by provincial marketing boards and the subject of provincial legislation. The United States has taken particular exception to changes in dairy policy under Class 7 pricing. However, the U.S. has not been clear or unequivocal regarding what it objects to related to this policy change. The U.S. has complained about lost exports to Canada and isolated increases in Canadian dairy exports since Class 7 was put in place, but it has not substantiated these concerns. My understanding is that Class 7 is domestic policy developed to correct a very serious issue dealing with surplus skim milk in the Canadian market and was formulated according to WTO rules. Indeed, an effective Class 7 is simply fundamental for the Canadian dairy industry to grow or even retain its existing scale, given future multilateral pressures Canada will face, such as the Nairobi Agreement banning export subsidies. It has been crafted to meet domestic needs, consistent with international trade rules, with appropriate adjustments made where necessary. Thank you again for the invitation, and I look forward to participating in this morning's discussion.
Merci à vous, Monsieur Mossel. Vous avez mis en évidence des enjeux extrêmement complexes, y compris des enjeux fédéraux provinciaux au Canada. Et cette recherche de consensus que vous souhaitez, je pense qu'elle va vous attirer un certain nombre de questions tout à l'heure. Je vous présente maintenant Mme Brenda Swick, notre prochaine panéliste, qui est avocate, associée au cabinet Dickinson Wright, où elle conseille les entreprises sur les questions de commerce et d'investissement internationaux, sur les stratégies en matière de commerce international et les défis de l'accès au marché. Sa pratique comprend également les sanctions économiques, les contrôles à l'exportation et à l'importation, les lois anticorruption, l'approvisionnement public, les lois douanières et les mesures commerciales correctives comme les mesures anti-dumping et les mesures compensatoires. Elle a été aussi arbitre experte dans des différends présentés au terme du chapitre 19 de l'ALENA, conseillère pour différents gouvernements, dont des gouvernements provinciaux, dans plus de 15 différends qui ont impliqué l'OMC et l'ALENA. Elle a été aussi associée pendant de nombreuses années à l'industrie du bois d'œuvre du Québec, où elle a agi pour le gouvernement du Québec dans le cadre du différend canado-américain, un différend commercial persistant qui compte parmi les plus marquants du secteur commercial depuis l'ALENA. Alors, sans plus tarder, Madame Swick, la parole est à vous.
Thank you, Senator Saint-Germain, Senator Eagleton, members of the Senate, and ladies and gentlemen. Thank you for inviting me and giving me the opportunity to speak with you today regarding the current NAFTA negotiations. I must confess that I, perhaps like many others certainly on this side of the border, breathed a sigh of relief yesterday, even if it's a temporary one, when I heard that the once three amigos, arguably just two now, had issued a trilateral statement indicating that they would take a longer intercessional period to explore creative ways to bridge the significant conceptual gaps before returning to the bullpen to resume round 5 of the most extraordinary trade negotiations. But then again, these are extraordinary times in the United States. Over the past few weeks and days, we have witnessed an onslaught of one-sided deconstructive proposals from U.S. negotiators for that country's sole benefit, and which even their own negotiators know are unseemly in any meaningful trade negotiation, where good faith efforts and give and take are essential and undertaken by all parties, not just taking by one. As predicted, the U.S. came out swinging in the last and latest round of these trade talks, tabling proposals described by some as poison pills designed to compel the other two signatories to accept them or face a possible U.S. withdrawal from NAFTA. My remarks today focus on the proposals filed by the U.S. to weaken the NAFTA dispute settlement regime by either eliminating it or making it non-binding. The problem with this approach is that trade agreements only work if they have teeth, and they only have teeth if they have binding dispute settlement mechanisms. The first U.S. proposal was to eliminate Chapter 19 of the NAFTA, or at the very least, make the panel decisions non-binding on the country imposing the anti-dumping or the countervailing duties. The U.S. continues to take the view that it will not be bound by the decisions of foreign courts, and in their view, a binational panel under Chapter 19 is just that. We have seen this play out in the last round of litigation in the softwood lumber dispute. In that case, under Chapter 19, Canada successfully challenged the U.S. International Trade Commission decision that Canadian imports of softwood lumber were threatening to cause injury to the U.S. producers. The Extraordinary Challenge Committee upheld the NAFTA panel result. Immediately, the U.S. producers, the U.S. Coalition for Fair Lumber Imports, challenged the ECC determination in the U.S. domestic courts, arguing that it was unconstitutional because only U.S. courts can rule on U.S. matters and administrative decisions. So to some extent, the U.S. proposal in the NAFTA negotiations to eliminate Chapter 19 is not surprising, unsettling, but not surprising. It is also that you need to consider whether the elimination of Chapter 19 is a deal breaker, in the sense that Canada does have the WTO dispute settlement process to rely on, as well as the U.S. domestic courts. Not perfect by any means, but two alternative avenues of recourse outside of Chapter 19. But the U.S. did not stop at Chapter 19. It then filed a proposal to effectively gut any enforceability of a Chapter 20 panel decision. Chapter 20 is the state-to-state dispute settlement panel mechanism, which allows one state to complain to a panel if the other country is not abiding by the substantive terms of the NAFTA. There have been a lot less of these cases filed under Chapter 20, but the principle and the rule of law enshrined in Chapter 20 is important. Under Chapter 20, a responding country has the right not to implement an adverse NAFTA panel result. However, if it chooses not to implement, then the complaining party has the right to retaliate against that country up to the level of nullification impairment of its rights under the treaty. The current U.S. proposal would change all of this and allow a responding country to ignore an adverse panel result and allow it not to implement it if it feels that the panel's decision is clearly erroneous. This eliminates the binding nature of dispute settlement in NAFTA because there is no remedy for noncompliance. Under the current Chapter 20, a complaining party can always retaliate against a non-compliant country for failure to implement an adverse panel result. And then there is the U.S. proposal to change Chapter 11 of the NAFTA, which is the investor-state dispute settlement regime. Essentially, under Chapter 11, an investor in one of the NAFTA countries has the right to sue a host government for damages for expropriation of its investment or for a violation of the right to provide fair and equitable treatment. The U.S. proposal is to allow countries to opt into that regime. Although there are very many foreign investment protection treaties around the world, investor-state provisions in trade agreements have seen pushback from civil society. For example, we've seen this in the newly provisionally implemented CETA, which requires each individual EU member to ratify implementation of the investor-state provisions before they take effect. So in my view, the U.S. opt-in proposal for investor-state dispute settlement is not as startling as the other proposed changes to weaken NAFTA's overall dispute settlement regime. So in closing, one of the biggest achievements of the NAFTA in 1994 and the WTO at that time was the introduction of binding dispute settlement mechanisms, whereby countries had to comply with adverse panel results or face retaliation. For the first time, trade treaties had teeth. With a weak dispute settlement system, trade treaties are not enforceable. And with this approach, you return to the days prior to the WTO and NAFTA, those days of the GATT, non-binding dispute settlement, and general trade diplomacy and handshakes. The lack of binding dispute settlement mechanism and therefore the enforceability of the trade agreements allows countries to pursue bullish protectionist measures without discipline to the detriment of their trading partners. This appears to be what the U.S. is looking for in these negotiations and others. A world of protectionism with side room deals, handshakes with no enforceable trade treaties accompanied by binding dispute settlement. In my view, that is a significant step backwards, not forward. Thank you.
Thank you very much. Before I go to our fourth and final panelist for his opening remarks, I want to remind colleagues at the table that we have a list here. I've got a couple names on it so far, so if you want to be added to the list for questions or comments, I think we're going to have to limit it to one question each given the size of our crowd today at the table. And again, I want to remind the audience, those people in front of me, that you can participate as well. Just let Agnes know if you want to ask a question or make a comment. We can give you up to 3 minutes at microphone number 5 for that purpose. So our fourth panelist, and all of them have been excellent, and I know he will be too. Jerry Dias is the national president of Unifor. That's Canada's largest private sector union. He's been active in the labor movement for nearly 4 decades. He began work life at de Havilland Aircraft, now Bombardier Aerospace, another company in the news, of course, this week, as it is a lot of weeks. He served initially as a steward, then a plant chair, and eventually the president of CAW Local 112. In 1993, he was appointed to the union's national staff as the aerospace sector coordinator. In 2007, he was appointed to the position of assistant to the Canadian Auto Workers National President, and I think we all know that he's an effective negotiator, and he's led numerous campaigns, including many that have prevented workplace closures and others that have led to the implementation of important improvements for workers' safety rights. Jerry Dias.
Well, good morning and thank you. Let me start off by thanking you for the invitation to speak here today. I'm glad to be sharing this space with Mr. Mussel and Ms. Swick, and I'm very interested to hear, and I was very interested to hear their points of view on NAFTA negotiations and trade issues more broadly. And I was also pleased to hear the comments from my friend Michael Geist. Him and I participated on a TPP town hall in downtown Toronto about a year or so ago. Imagine this event today will be a little less rowdy, probably less heckling than we went through in Toronto, but boy, I had a great time in Toronto. Trade is a virtually important topic for Canada today, and NAFTA in particular, and I'm glad to be having this discussion with you. You know, it's interesting because people perceive the labor movement as being Neanderthals and want to build a wall around our country. There's only one person that wants to build a wall, and they don't live in Canada. But ultimately, listen, we understand. I represent 315,000 workers in Canada. 85 to 90% of everything we manufacture is exported. So nobody understands the importance of export and a strong export plan than I do. So I want to cut right to it. I think NAFTA has been a disaster, a colossal disaster in many different ways. Obviously, I can't generalize, can't say that every sector has been negatively impacted because that would be incorrect, but on major manufacturing, it's clear. If you look at manufacturing, pre-NAFTA, we had a small trade surplus, was pretty well balanced. Today, we're sitting at about $120 billion deficit. So when I hear people say that it's been good for working class people, I'm curious, working class people where? We've lost 500,000 manufacturing jobs here in Canada. People will say, geez, that's as a result of technology, that's a result of a whole host of things. And the technology argument might make some sense if you're talking about the auto industry, except that as we close 4 auto plants here in Canada, and they closed 10 in the United States, they've opened 8 in Mexico, when they're opening 2 more, where the workers at the BMW plant are going to make a whopping $1.10 an hour. So if they live to be 180 years old, they'll never be able to buy the car that they're building. Obviously, an exaggeration. So look, I think my views about this have been well documented in Canada, American, and Mexican media over the last few months. And I'm honored to play a role with the Canadian team as we express our point of views of what needs to be changed in order to have this as a trade deal that works for everyone. In our submission to Global Affairs earlier this year, we referred to NAFTA as a symbolic starting point for a new neoliberal model of trade and globalization, a trade pact that sets rules making it easier to move investments across the borders, rules that give extraordinary powers to corporations, allowing them to sue governments and challenge laws that impede profits through private tribunals, rules that limit our government's ability to set economic and social development policy in key areas unless they are specifically safeguarded, as in culture and public health services. Worse, NAFTA and trade treaties like it pay lip service to the rights of workers and the environment with text that's unenforceable and virtually meaningless. Right now, trade rules don't serve the broader public interest. That's not what trade deals were designed to do. We have to change that. And since NAFTA is the first trade treaty we've opened up for renegotiations, this is a great opportunity to set a new direction. I want to read you a quote I dug out of an old federal study on NAFTA. The study was published in January of 1993. In one part, the report said, eventually, Mexican wages are likely to rise closer to Canadian wages as Mexican labor productivity increases and the economy grows, but this may take some time. Well, no kidding. Minimum wage in Mexico, 65 cents an hour. The highest paid auto worker in Mexico makes under $4 an hour. Average wages in a Mexican assembly plant is $2 an hour. Almost 50% of all workers in Mexico live in poverty. So when I meet with the different groups and the different stakeholders, and we've been saying publicly in Mexico, which has been very important, because the Mexico media and the workers in Mexico are appreciative. So here we are in Canada, and Canada is proposing to increase the standard of living for Mexican workers. The United States, not as aggressively, is talking about increasing the standard of living for Mexican workers. The president of Mexico is determined to keep his citizens in poverty. I can imagine the election campaign next year. Canada wanted to raise the standard of living. The U.S. wanted to raise the standard of living. But as your president, I was able to keep your wages suppressed. Great campaign. Anyway, don't get me done. Let me get back to my script before I lose my mind. You know, listen, It never was about raising the standard of living for Mexican workers. This is about suppressing wages in Canada and the United States and having the corporations saying to labor unions like mine and working class people that we have options. And those options are in Mexico, where we pay our workers virtually nothing. So look, it's been 25 years and Mexican wages have not risen. After adjusting for inflation, wages in Mexico have fallen since NAFTA was signed. That's right, it's fallen, not increased. Like I said, half of Mexico's population lives in poverty. I raise this not because I want to shame Mexico. Over the years, unions in Canada have worked in solidarity with free independent Mexican trade unions. But if you look at the Mexican industrial strategy, they have what we call yellow unions. They're called the CTM, which represents 90% of the unionized workforce. And of course, they're not a real union. We call them a yellow union. They sign protection agreements like the $1.10 an hour with BMW for a plant that's going to open in 2019. So there's a lot that has to be done here. So I'm not criticizing the Mexican workers, anything but. As a matter of fact, we lost our jobs. Many of them got the jobs, but were never compensated in order to enhance their standard of living. And here is what is wrong with NAFTA, and it was one of the things that we seriously need to fix. So what good is free trade if these are the outcomes it produces? NAFTA is a complex deal, and there's a lot I'm concerned about. But in these negotiations, I'm very glad the issue of labor rights has become a priority. And I give a lot of credit to the Canadian team and Christia and Steve Verhoel and the bargaining team for raising these issues. It's a testament to this government's ability to listen, to involve the labor movement in their consultations, and to look at trade and globalization through a broader social lens, including on issues of gender and Indigenous rights. How these issues get addressed remains to be seen. Personally, token gestures, a few short clauses won't cut it. If this new agreement is to have to enhance standards and be progressive, then these social clauses have to work their way into many areas of the text. What burns me is how our trading partners, particularly in the United States, don't seem to be taking this very seriously. On one hand, I'm talking about how these social clauses are being treated. And from what I'm told, proposals to discuss gender and Indigenous rights are being met with eye rolls. The United States has signed 2 out of 8 ILO labor standards. They have yet to sign gender equality. 2017, we can't agree that women and men are to be paid the same. It's fascinating. I listened to Brenda talk about Chapter 19. Without a dispute mechanism and a trade agreement, it's kind of will be like the United States, like Colonel Sanders taking care of the chickens. I mean, there'll never be a dispute that Canada will ever win, even if we are in the right. On labor, the U.S. is digging in its heels, pushing for language that mirrors the TPP, the same language that was just tested in the first ever trade dispute on labor rights with Guatemala that failed miserably. The dispute in Guatemala was about 54 labor leaders that were murdered, human rights violations. The courts ruled that, yes, this has all happened, but because they couldn't prove that it didn't negatively impact trade, it wasn't a violation of the Guatemala-U.S. trade deal. The demands they tabled so far are so far out of left field and so narrowly focused on their own self-interest, it's hard to see a pathway for any deal to get done. On the investor-state dispute settlement, the U.S. concerns are not unlike ours, but rather than eliminate ISDS in the agreement, the U.S. wants to eliminate it for them and force Canada and Mexico to opt in or opt out. So that's allowing U.S. corporations to sue Canada, but Canada can never sue U.S. or never could sue the U.S. It's just fascinating. On procurement, the U.S. not only wants to retain its ability to set by American rules, which isn't necessarily a bad thing, by the way, but it also wants to severely restrict Canada and Mexico current access to bid on projects. Let me know when I'm running out of time, and I'll. On auto, the U.S. seems to think that setting higher standards of rules of origin thresholds, including a ridiculous 50% U.S.-specific contact rule, will help reshore jobs and production. And we said repeatedly, their approach is not only unfair to Canada and Mexico, but it misses the bigger picture. You need to understand, their 50% that they put on the table will eliminate the steel industry here in Canada. It'll wipe out our auto industry here in Canada. It'll wipe out the auto parts industry here in Canada. Because as a quest for 50% U.S. content, the jobs will just migrate there. So there's a lot of issues in play here, and I want to talk about what we've just went through. We just settled a strike at Cami and Ingersoll that went on for a month. And we said it was the poster child for what's wrong with NAFTA. You see, our Cami assembly plant is the most productive plant in the world. German, Asian, Italian. I can walk through every auto-producing nation in the world. The #1 productive plant, built more cars with less people. 8 years, we worked 6 days a week. They made $2 billion profit a year. We had a 1-month strike. Why? Because they moved our Chevy Terrain to the San Luis Potosi plant, where they're paying their workers $2 an hour, and then they dual source their Chevy Equinox. So instead of building 400,000 cars a year, we're going to build about 190,000 vehicles a year, and we just lost 600 jobs in the most productive plant in the world. So as Canada, if we can't maintain jobs with the most productive plant in the world, we'd be naive to believe we can keep them, period. So this is serious hardball. NAFTA renegotiation is about fixing what is wrong with trade agreements. You can't have a trading partner where you have right-to-work states in the United States that don't believe in free collective bargaining, and Mexico, which is determined to eliminate any form of free collective bargaining, and they do that through their Mexican industrial strategy. So thank you very much for allowing me the opportunity to present and someone to vent.
How could we tell? Okay. Thank you very much. 4 excellent speakers to start off this session. We've got some 8 senators on the list so far, and we can still add some, but given the number of senators here, if you could keep it to 1 question, please, each, and we can always develop a second round if we have more time. And again, I remind the audience. So to see Agnes, starting with Senator Terry Mercer.
Thank you, Chair, and thank you all for your presentation. I've got questions for all of you, but I'm going to stick as the Deputy Chair of the Senate Standing Committee on Agriculture and Forestry. I think I'll talk to Mr. Musil about the issue of supply management and the constant musing that we hear from Americans about these subsidies that are involved in supply management. I've been a member of the Senate Standing Committee of Agriculture and Forestry since 2003. I've yet to find a subsidy in the Canadian agriculture sector. I've yet to find particularly a subsidy in supply management. What I found is our farmers and the sector willing to manage the sector to the benefit of Canadians and to the benefit of farmers, so that we have an agricultural sector in this province, in this country. I also constantly remind people that subsidies is a word that the Americans don't use. They use a word, they describe it as risk management. This is what they call it, risk management. That's why the most important piece of equipment today on an American farm is the mailbox, because that's where the check comes in from the government, and it's under the heading of risk management, known in every other country as a subsidy, but they don't have subsidies. I'm very concerned that supply management is on the table here, and it's even being discussed. I'm very concerned that our government will even entertain any discussion of supply management. Particularly, I understand the Americans particularly are talking about dairy. The issue to me is you have to. How do we get this message across that supply management doesn't cost the taxpayer any money out of the Treasury? This is an ongoing problem that we have, and I take every opportunity. This is another one to say this. So, Mr. Musil, what do you think?
Musil, and I might add, if after Dr. Musil says something, any other panelist wants to weigh in on this or any other question, just give one of us a signal.
Thanks very much for your question, Senator. And I guess I'd open by saying quite correct. There are no subsidies, monetary subsidies in form of a check in the mail that are part of programs, supply management programs for the various commodities. And I think members, people on the government side as well as certainly the industry side, I think probably believe that one of the important elements of whether we're talking about milk supply management or chicken supply management, eggs, et cetera, I think many would view a very important element being that it is it's essentially subsidy-free. Now, the one difficulty we have, and it may be viewed as somewhat technical, is the issue of export subsidies. And they relate to dairy specifically, and they relate to a past WTO dispute. And the settlement of that dispute having to do with dairy exports, which goes back to 2003, in the settlement of that dispute, Canada agreed that it would limit. So first of all, our exports of dairy products at that time were found to be implicitly subsidized, and that we would limit our exports to subsidized export levels that were reported and agreed upon at the time of the WTO Agreement on Agriculture in 1995. The reason that that's relevant today is with Class 7 milk, we have a mechanism of milk marketing which allows for pricing of milk components at the world price without being contingent on export. And that allows us to have exports that are non-subsidized and therefore come outside of those caps.
Okay, panelists? Okay. Next.
Senator Marois.
Thank you, Chair. My question is for Professor Geist. Thank you for your comments. I must admit I do share your views on the importance of IP in an increasingly digital world. One of the three things you said that we should try and do is respect the IP protocols or standards that are in existing agreements. But the question I have is, are we comfortable that those standards are in fact fair and appropriate, given the fact that the U.S. was first out of the gate and way ahead of everybody else in understanding the importance of IP and its importance, and I suspect a lot of those agreements have a heavy bias in favor of the U.S.? And related to that is a question is IP really getting the attention it deserves in the NAFTA agreements? My worry is that it's not very well understood. People, certainly not by the general populace or by media, and it doesn't get much attention. And if we don't get it right, we run the risk of becoming what I call a modern-day colony in a digital world. So are we comfortable that we're getting it right?
Well, thanks for that. Those are both good questions. I'll start with the issue of whether or not the international agreements are fair. And I actually think that in many instances they are, because they reflect something that Canada's done very well at typically, which is in a multilateral international environment. You can find consensus with a lot of like-minded countries that sometimes face some of the same kinds of IP pressures that we face. What the U.S. has tried to do, and where it's obtained some of the advantages that you describe, is to take those international agreements and then gloss on it their own interpretation of what they would like to see happen, and then try to implement that through trade agreements. So the international agreements are oftentimes a standard followed by many countries, followed by Canada, that actually provides the kind of flexibility to better reflect the specific interests of any individual country. What the U.S. seeks to do, whether it's in NAFTA or and they tried to do it in TPP and in a number of other countries, is to, in a sense, reinterpret some of those international agreements for their own benefit. The danger we face, and why I've emphasized that what we really need is not an Americanization of the IP provisions, but rather a reliance on those international standards, I think, is to resist some of that pressure of a reinterpretation, largely, as you say, I think quite rightly, to U.S. advantage. Now, is this getting the attention that it needs? As I mentioned, I think a couple of times in opening remarks, I think certainly Canadian negotiators are obviously aware of this issue, and there are long-standing tensions over some IP issues between the United States and, quite frankly, just about every country in the world. It has used trade negotiations as a pressure point with just about everybody. The danger, I think, that we face, and it comes up both in IP as well as in e-commerce, is that when you hear about all these other issues, which of course are enormously important, there is a danger that I think this does get lost in the shuffle a little bit. That say, well, in the scheme of things, We can't have an agreement, as we heard, without a real dispute settlement policy. We can't have an agreement that lays waste to our agricultural system. And so there is a danger that one of the things that happens is we say, well, let's just give the United States what it's looking for on IP as part of that bargaining process. And in the process, I think the danger is that we, in a sense, sell out where much of the future economic growth and innovation comes from in our economy.
Would another panelist add a comment? No, it's okay. So, next
Senator
question.
Lang.
Thank you very much. Man, there's a lot I'd like to dig down into, but let me instead take it up to
One question. You know.
Oh, yeah, I don't know how to do that. I want to actually ask anyone who wants to contribute on this to step this up to a strategic level in your crystal ball of looking into the future here. This is the most interesting time, surreal set of international negotiations that I have seen in my lifetime. You just made the point about, IP and digital e-commerce. Those things may fall off the table because of the larger issues. Jerry, you spoke about, the labor, gender, indigenous, environmental, the social clauses. That was part of our discussion in the WTO and the FDA and the NAFTA and now again, and we've not made progress on those things. I'm thrilled that they're on the table, but how seriously we'll be able to move on them with the nature of the negotiations. It was recently at a Great Lakes parliamentarian gathering, so U.S. Congress, Senate, MPs around the table. AutoPact was certainly something that we spent time talking about, but we have interest in agriculture and in the other issues. There's a common front from the governors there of concern about what's going on. But if you go to right to work states and others, there's not. What are the internal pressures in the U.S. on the trade negotiations? And the difference between what those negotiators, who've got to know they're in a surreal world themselves in terms of what they're putting forward and arguing, their relationship to the administration and where this administration is taking it. I don't see what the route out is and the movement forward. Do you have any sense that the bluster will go away and a deal will get struck? Do you have any sense that this is going to blow up into a serious falling apart of international relations? I'm just at a loss because most of what other than your great presentation, most of what I get my information from is what I read in the paper, and it's not very informative about the way forward at this point in time.
Okay, broad question. We'll get it to other panelists. So let's start with Jerry Dias.
Look, we have to start preparing for life after NAFTA. Period. I mean, this thing has been heading in the toilet for a month and a half. Ultimately, the U.S. doesn't want a deal, or they wouldn't put the proposals on the table that they have put on the table. I know a little bit about contract negotiations, so I know about padding it up front and then maneuvering yourself as you head towards a deadline. But you can't put those types of proposals on the table and expect an agreement unless the U.S. is going to completely collapse at the 24th hour, which isn't going to happen. NAFTA is, look, the interesting piece about this set of renegotiations of NAFTA is the issue, we've talked about people, which is a first. We talked about economics, which is what it should be about, but this NAFTA renegotiation is all bit about politics in the United States, and so you're not going to get a deal that's strictly about politics. We had to know this thing was going nowhere quickly. If you take a look at what the U.S. is saying, they don't want a Chapter 19, yet they slap outrageous tariffs on our softwood lumber when they know they can't win if it gets to an independent tribunal. They've lost every case, I think, since 1982 or 83, every one. And then, of course, we have this whole ridiculous fight with Boeing and Bombardier where the U.S. Commerce Department slaps 300% of tariff and led, of course, to the deal that Bombardier just did with Airbus. So, look, where is this thing going to end up? The world is preparing, there's no question. Asia, Europe, everybody's talking to Canada about what life looks like after NAFTA because no nation around the world is going to be pushed around by Donald Trump, and that's the straight politics of what's going on internationally. So we don't have to take a secondary position here. Because if NAFTA falls apart, the agricultural industry in the United States will go crazy. And you know that as well as I do because the tariffs. Agriculture is big news, big time in the United States, one of their biggest export industries. Tariffs will hit anywhere between 15 and 100% based on commodities. Dairy, they already have 5 times the access to Canada than we do to the United States, and they're whining about our supply management situation. In the original NAFTA, we surrendered a lot. We gave up access to our water, oil, energy. If you look at the U.S. National Energy Program, Canada is listed as another state. So this is going to get ugly. This is going to get into some political hardball. So be it. So the United States, in my argument, will find out that the world will survive without them. The question is, can the United States survive without the rest of the world? And that's how this thing is unfolding. That's my guess. I have bets with every journalist in Canada, the United States, and Mexico. A bottle of wine that will fall apart before Christmas. I'm currently having a wine cellar built in my condo.
Okay, let's get another perspective. Brenda Swift.
Well, I think, first of all, just with respect to Bombardier, I think we have to keep a little, it's not great what's happened there. But remember, it's not the Department of Commerce that petitions, it's the industry. So, you hear a lot in the press that the United States has, imposed these tariffs or whatever, but the only reason that they're there, the United States didn't unilaterally initiate against Bombardier, the government, their competitor did, and they're allowed to do that. And that's, that's one of the parts of the trade agreement. But, when we're talking about 300%, well, Canada Border Services Agency last year, I represented some gypsum contractors and in Western Canada. And Canada Border Services Agency, I think it was a company called Certainteed, filed a dumping petition and against imports of gypsum from the United States, and the duties that Canada Border Service Agency imposed on imports of U.S. gypsum were 300%. And you can imagine the havoc that caused to contractors in Western Canada and Fort McMurray and wherever, where they had priced jobs on the basis of pre-duty pricing. So, they were getting this huge uplift in price. So I just, on the 300%, in the world of steel, you see those duties of those margins. So, it's not great what's happened to Bombardier. There's going to be a lot of issues around that. But, it's Boeing that filed the complaint. The U.S. government didn't unilaterally initiate that. In terms of what lies ahead, it can get... Listen, I have a lot of colleagues in the United States at U.S. trade law firms, and we're spinning this all the time, right? Because it's so uncharted territory. Because there is no U.S. legislation to deal with the withdrawal process. All you know is that it's all about Congress, and that's why the Canadian government has been quite smart in their approach to that all trade is local in the districts, because NAFTA is just a treaty. You can have a treaty, but if it's not ratified and implemented in the domestic law, it doesn't mean anything. So Trump, if he wants to, sign away, who said he thinks he can, well, maybe that'll go to the courts. He thinks he can withdraw NAFTA, but ultimately, you've got implementing legislation in Congress that is going to have to be changed in the NAFTA Implementation Act. So what you could foresee, and I think a lot of companies or interest groups might be doing this, is if NAFTA is going to go away next year, however, we don't get a new deal or there's a unilateral withdrawal, then that NAFTA domestic implementation legislation before Congress has to be changed. It has to be replaced and repealed, or repealed and not replaced, but something has to happen. And that's how you get rid of it. And that means that you're going to see a huge amount of lobbying on Congress when the Americans actually take notice of it. Because right now they have, they're on tax reform, but when, Congress actually really gets involved, and that, this issue I don't think is going to be decided in Washington. I think it's going to be decided in the states, in the localities, and I think that's why the government of Canada was quite smart in the strategy that they've got. because that's where it's going to get settled, because ultimately that implementation legislation, just as in Canada, has to go away. You've got to repeal it. And there's going to be a lot of debate about the repeal of that legislation, and you can see it can get very, very messy. Because let's assume that you want to keep, let me give an example. With the NAFTA implementation legislation in the United States, you've got a global supply chain between a U.S. company and a Canadian company. And that U.S. company lobbies Congress, and they say, you know what? When you're with the NAFTA implementation legislation, when you're repealing, replacing, whatever you're doing with it, make sure you keep my preference that I've got in this particular product or this particular industry. Make sure with Canada, I want to keep that. And then what that will do is, and then they'll lobby Congress, and Congress will make the changes to the legislation to keep that preference to Canada. And then you might get a lot of those little preferences going on as people start lobbying. So it becomes really quite a storm. But then what happens is you're not giving all these preferences to Canada under the protective umbrella of a free trade agreement, which is an exemption to all of these WTO commitments. It's just the United States giving preferences. Canada might do it the other way with their legislation. So then what happens is WTO third parties say, hey, how come you're giving a preference to Canada, I'm in Europe, and you're not giving that preference to me? And then, that initiates some sort of a WTO dispute. So my view in going forward, I think it's going to get very messy. I think it's the only thing that I do know is that Congress will be involved in any repeal and replace, because they have to, because it's the implementation legislation has to go. And that's going to be a domestic fight.
In addition to Congress, I might add the state governors. I was at the governor's conference in Rhode Island with the Prime Minister and Premier Wynne in June, and they're very concerned about it. 35 of the states, their number one trading partner is Canada. Professor Geist.
Sure. I was just going to add quickly, I too rely on media reports, although there's specialized publications that provide more information. In the area of IP, it seems to me that there is a bit of a disconnect emerging between the President and the U.S. Trade Representative who does the negotiation. USTR is traditionally, and I think will on an ongoing basis, promote IP as one of its core objectives. That's been the case for the last 2 decades. I think it's fairly obvious the Trump administration is far more focused on conventional manufacturing and those sorts of issues, and the extent to which they're going to prioritize what would be viewed as Hollywood-type priorities around IP. It seems to me that is less of an issue, potentially less of an issue, at least from the President's perspective, than it has been in the past. I think the point of life after NAFTA is an important one, especially in the context of IP. And I would note that, in a sense, Canada has already started down that path with some of our other trade agreements. And so if you look at the IP provisions within CETA, if you take a look at the IP provisions in our trade agreement with South Korea, they hew far more closely to an international standard and leaving the flexibility for each country or each trading region to implement rules within an international framework, but according to their own priorities. The U.S. is, in a sense, an outlier when it comes to that kind of approach. And so we've started down that path, and I think in some ways it's a far better one that serves our interests and will line us up nicely as other countries begin to talk to Canada about what are the possibilities for increased trade, and we can come to the table with something that will be recognizable from their perspective when it comes to these issues.
Al Mussel.
Great question, Senator Lankin. You made reference to perhaps some discomfort that we've read about in the media among the U.S. negotiators with some of the instructions they've been called to carry out. In the ag and food sector, we know the U.S. Ag and food industry, the key message they have sent to the administration is don't mess up NAFTA from at least 2 perspectives. One is Canada's an exceptionally good export market for them in finished food products, and they fear the potential of tariff barriers, and they want in. It's a great market, so of course they want in. The other thing that they worry about significantly is the raw product supply that feeds into U.S. manufacturing, and one of the things that we looked at earlier in this year was just the extent of of breakfast cereal manufacturing in the U.S., which has an export market in Canada, but absolutely dependent on Canadian oats. Absolutely dependent. And the food industry in the U.S. is well aware and deeply concerned about this. And there's a number of other examples. One of the worries that I have is if this thing devolves, as Brenda made reference to, is that this could just begin to lead to a whole bevy of disputes. I think we can, well, and I doubt if the U.S. will feel limited by being involved with us in a NAFTA negotiation in terms of bringing bilateral disputes. There's probably precedents for that, of countries being in negotiations and one of them turning around and bringing a trade dispute. But, well, we already have one out against BC wine. Wine will be a contentious issue, and that's a long-standing contentious issue. We can anticipate a dispute probably in dairy, perhaps on a range of parameters. And right now, within the framework of NAFTA, we're working, I think, pretty collaboratively on regulatory reform. But if that dynamic begins to break down, then you know, regulatory issues can be attacked in not such a collaborative environment. And I don't think anybody is better off as a result of that, but that can occur. And I guess finally, the difficulty we have, you know, good for us, we've got a freer trade agreement with the European Union. We're exploring others, including taking some of the lead on a TPP 11. The difficulty is in farm products and a lot of food products. Naturally, the U.S. is going to be our largest trading partner because of the bulk nature and perishable nature of the product. And that's going to occur perhaps regardless of what happens here. We could just end up being far worse off as a result.
4 great answers to a great question. The next question will be asked in French by le sénateur Éric Forêt.
Merci, Madame la Présidente. Écoutez, un peu dans l'optique de la question de la collègue, la sénatrice Lenkin, puis je voudrais, avant de gager, je ne voudrais pas augmenter l'inventaire du salier à M. Dias, engageant avec lui, mais quand je regarde la situation, le portrait global, où, d'une part, on a une entente entre 3 partenaires depuis plus de 20 ans. Un partenaire qui a des règles du droit du travail beaucoup plus, je dirais, beaucoup moins contraignantes et exigeantes que les nôtres. Peu de soucis au niveau des exigences en termes de règles quant au respect de l'environnement, qui est un enjeu majeur. On a un autre partenaire qui veut une entente à tout le moins inéquitable, qui ne respecte pas l'ensemble des règles cadres qui doivent régir cette entente-là. Puis on a, nous, le Canada, qui sommes... je me pose la question, quel prix devons-nous payer pour signer ou re-signer ou renégocier une entente comme celle de l'ALENA? Jusqu'à où devons-nous nous rendre comme compromis? Quand je regarde les enjeux au niveau, que ce soit agricole, que ce soit au niveau du commerce électronique, que ce soit au niveau carrément des biens de production plus traditionnels, on peut considérer dans cette négociation-là difficile jusqu'à quelle hauteur on est en mesure de dire on va payer un prix assez élevé et pour qu'en bout de ligne, on soit quand même gagnant d'une entente comme celle-là.
Qui se risque? Les risques versus les avantages.
Well, let's start off with the environmental issue, because you're absolutely correct. If you're looking at 2 areas where Mexico has created an environment to attract investment, is A, of course, under their low labor standards. B, well, 3 pieces. They have signed a lot more free trade agreements with other countries around the world than, frankly, Canada or the United States has. But there's no question, when you don't spend money when you don't have environmental concerns, it's a major investment you don't have to make in your manufacturing facilities. So that's why the issue of environmental, as well as labor standards, are connected at the hip, not because of the whole issue of just the importance of the environment. I do like a place for my grandchildren, but it's a cost, and it certainly is a cost issue. Now, you asked an issue on what it is we're prepared to sacrifice, and I'll argue we've already sacrificed too much. And I raised it in my earlier comments. Canada's three major industries, export industries in Canada, are auto, oil and energy, and forestry. So right now, two of the three are under attack. And the only reason that oil and energy isn't under attack is because the United States needs it. So in the initial NAFTA, we gave the United States access to our electricity, even if there's a shortage in Canada. Let me give you an example, because I represent about 25,000 workers in the forestry sector. Every day during peak hours in Atlantic Canada, our mills are down because we're shipping our electricity to the United States. So we're shipping electricity to the United States industry while ours are sitting dormant, because that's the deal that was carved under NAFTA. So if you take a look at the fact that we form a part of the United States National Energy Program, what we gave up on water, then the argument becomes, what else do we have to do? Are we content signing an agreement knowing that there's going to continue to be an exodus of manufacturing jobs to Mexico because we're not going to do anything on labor standards? So I think it's time that we played a little offense, and I think that's what we're doing. So Francis had raised earlier on, how determined is the Canadian team to stick with the issue of labor standards? I will say they're very determined, because the one thing that has happened over the last few months, I will argue trade deals have never been discussed with so much profile and so much involvement from the citizens of the three countries than NAFTA. So the whole argument about Mexico and their labor, there won't be a deal, and they know that. I've met with the Mexican ambassador to Canada. I've met with the Mexican labor team. So we've had a lot of discussions. People understand that it has to change. So now's a question, in my opinion, of playing a little offense, and I don't see us having to surrender, frankly, anything more than we already have.
Just a brief supplementary. Sorry to interrupt you.
No problem.
But you just talked about electricity being shipped. Who ships the electricity? What companies do that to the United States, and what mills close? I mean, is that a well-known fact within the Canadian community or the maritime community?
Well, the maritime community is well aware, but the electricity goes straight from Quebec to the east coast of the United States. If you take a look at the Irving mills, if you take a look, there's Resolute. There's a lot of mills. There's a lot of industry in the Atlantic region that shuts down and reduces production. They literally shut down. They reduce production. They do everything in order because of the straight electricity shift from Quebec to the East Coast.
Okay. Professor Geist.
Thanks. I just want to note, one of the challenges with the agreement, in answer to the question, is that I think for many, when they think of trade agreements, they think of tariffs and perhaps of oats or dairy or cars or even electricity, and how much gets into a country and the like. Where a lot of the contentions lie and where these new trade agreements are is not on those issues anymore at all. I mean, those issues are quite clearly still there. We just heard about that. But when we're talking about, let's say on IP, we're talking about a knowledge economy, and we're talking essentially about national regulation. If the e-commerce chapter may be described as an e-commerce chapter, but if you take a look at the priorities that the U.S. has identified, and I saw just now that the Commerce Secretary just talked about it this morning, they're fundamentally talking about the privacy rights that get established in a given country. Now, how do we quantify that? How do we say what level, what standard should we be able to establish, both for our security and our privacy, and how much are we willing to give away in order to have an agreement? It's a tough issue. I don't have an answer. I don't know that anybody does. But what I do know is that it becomes a very difficult thing to quantify as part of a negotiation, when oftentimes we focus much more on the tangible and less on these kinds of issues that will have a fundamental effect on the privacy of all Canadians, on the education of our kids, if you're talking about something like term extension.
Yes, please go. We have 5 other senators that want to ask questions.
Your question was, what price are we prepared to pay? And of course, that's a complex question. But I think one obvious line that we cross, frankly, has to do with sovereignty. And remarkably, just in the last number of days, we've heard that the United States has requested that it have final approval for any changes Canada would make in supply management systems, and that Canada agree to phase out supply management in dairy, poultry, and eggs within the next 10 years. And the reason that, in my understanding of it, I would see that as a line that we cross is these are domestic policies in Canada. And domestic policies in Canada are made by the federal government and its provinces. They're not made in Washington or anywhere else. So I really find it remarkable, going back to Senator Lankin's question about the relationship between the negotiators and the administration. Surely the negotiators must have had a sense that that type of request would be probably unacceptable to Canada, and you know, it leaves you wondering why they would ask for that to begin with. And just very quickly, Mr. Diaz mentioned the idea of playing offense, and you know, maybe some people think that this is un-Canadian or something, but we may have no choice. We may have no choice. If NAFTA begins to dissolve, and we certainly hope it doesn't, and we begin to get this spate of trade cases brought against Canada, and I can think of a number possible in agriculture and food, we may have no choice but turn around and take trade cases against them. And there'll be no choice. And it's a shame. It's a shame. It shouldn't be like that, but we need to be prepared for that.
Brenda doesn't. Before I go, we have Senator Therese Gagné, but followed by Senator Joyelle, Day, Massicott, and Wu. And still don't have anything from the audience, but there's Agnes if you want to get in on it. So, Senator Therese Gagné.
Merci beaucoup. Je vais poser ma question en français. Alors, il est clair que les États-Unis souhaitent réduire ou, dans certains cas, même abolir les barrières aux investissements dans tous les secteurs. Il y a question que les États-Unis aussi souhaiteraient percer des marchés que le Canada considère de sacrés, c'est-à-dire la santé, la culture, l'éducation postsecondaire. Je me demandais, est-ce qu'il y a parmi des secteurs que nous considérons sacrés, des secteurs qui seraient dus pour une réforme dans le contexte de NAFTA? Le NAFTA. Okay.
Okay. Who wants to tackle that first?
I'm not sure if I understood the question.
Yeah, no, I'm not sure I can.
Could you repeat the question?
Is there any sector? Est-ce qu'il y a un secteur qui est prêt pour une réforme? Je peux peut-être penser à la télécommunication dans le contexte des négociations de l'année. C'est ça, NAFTA.
I'll start by where I would have turned to. So I think the telecom sector would be a good example where I think the arguments that we long had around with some of the protectionism and limitations on foreign investment in the telecom sector don't apply today. And even if you can make an argument that there may be some benefits, the costs that we're paying, quite literally as consumers, with a reduced competitive marketplace in telecom, I think represents a real problem. And so to the extent to which I'm not in favor of using trade agreements as a mechanism to change domestic policy. Frankly, we ought to be changing our domestic policy just because it's in our interests to do so. But if we were to further open up our telecom market to invite greater levels of competition, I think that'd be a good thing.
Anybody else? So,
Merci.
good.
Would you like to
Madame
add?
Swift?
Yes.
Yes, I might add something there. It's a little bit of an arcane issue, but it's got to do with forestry policy. I might add that, you know, there's kind of a, I would say, an arcane policy out in British Columbia that logs harvested from private lands have to be offered up to a domestic processor before exported. And these aren't public lands, these are private lands. They're on the coast of BC, and it is a terrible trade irritant with the Americans on softwood because it has permeated into a subsidy that affects even Eastern Canada. And to me, that is an easy fix. You're not to eliminate log export restrictions on private lands, but keep them on the vast majority of public lands. These are private lands held by private individuals. And, you know, I think that if that could be part of the renegotiation, that would probably be a very good thing and an immediate removal of a trade irritant.
I think in many people's minds, dairy or supply management in general would fall into the sacrosanct category. And I think one of the things worth mentioning is that, as I mentioned in my remarks, this is poorly understood. Supply management sectors have been evolving over the last 40 years almost continuously. And we will continue, particularly with regard to dairy, there will be progressive policy evolution that will occur, frankly, regardless of NAFTA. NAFTA may, depending on what happens here, that NAFTA may accelerate it or impact in some ways. But this was going to happen anyway, and it has to happen. I think it's a very positive story, but we need to understand that.
Merci à vous quatre. La parole est à vous, Sénateur Joyal.
I have two questions. The first one is Professor Guest. We're lucky in Canada to have the Charter because there are limits to what the Canadian government can trade in terms of privacy protection and in terms of inflow information related to Canadians to a foreign country. So I feel that at least we have some limits, constitutional limits, that protects Canadians. And I would certainly resist any kind of deal whereby we would open the door to a greater flow of information that would endanger the kind of society we benefit in Canada. That's my first question to you. My second one is about the old picture. And my question may be to Madame Smith. My perception is that from the beginning, the United States didn't have that much complaint against Canada. It was more about Mexico. And as Mr. Dias has mentioned, it's where the unbalance is. It's not with Canada. We know it. And I think that any reasonable person beside the President would understand and recognize that. So I don't think that NAFTA as it is now will survive. I totally agree with you. The United States want to have a fight with Mexico, not with Canada. So if the deal falls, my perception is that their first priority will have to have a deal with Canada. And of course there will be some kind of fine-tuning, as President Trump said, at the beginning of his comments about the survival of NAFTA. But we have to take our interests on the longer-term basis than to be caught into the dancing of the politician, around the fire at this stage. And I don't want to make any allusion to any kind of cultural habit or tradition here. But I think that for Canada, we have to recognize that the deal is over. There will be some bumpy road at a point in time. We will have to give some concession to a new bilateral trade, as we had, with the States in '89. Don't forget that NAFTA started first between United States and Canada, and we will come back to that. I mean, it's not the end of the world if NAFTA fails. We will come back to the FTA. And I think that we have to understand that, and I'm making that to Mr. Muscles. When we signed with the European last fall, we made some trade in relation to, dumping some of the French cheese over the Canadian market, and the government compensated, the cheese producer. So we know we have to fine-tune it. We won't abandon the whole of the supply and management policy, but there is possible fine-tuning when we sign a deal with, a larger market. So my perception is that we should certainly not fall into the psychological climate, around, oh, we're going to be ended there, it's going to be terrible, it's going to be the end of the world. I don't think it's going to be the end of the world at all. We will survive. We had already a deal with United States. I would say to anyone who is at the table, take the deal of 1989 and start with this and try to see what kind of arrangement. But if we want at this stage to give everything that the United States is requesting, especially Section 19, which is ludicrous. We said it from the beginning. There will be no NAFTA if United States say abandon 19. So I think we have to remain very cool in our approach in there and not fall into, and I'm not accusing the media, but the frenzy about, the last hour negotiations and all the tension and, like the final chapter of a Netflix series where you don't know who's going to survive the earthquake. We'll not survive the earthquake here. We have survived before. And, since 1982, we have signed 58 trade agreements. And we have 25 other agreements being negotiated presently. Canada won't fall. We might have in some areas, some fine-tuning, some uncertainty, and we know the economy doesn't like uncertainty. We all know that. But there is a period of readjustment. So to me, I would remain very cool at the bargaining table. I would look, ahead, Take your interest on the long term and the larger horizon, and don't panic, because the President of the United States has tweeted yesterday that, he doesn't like that kind of industry, or he make a comments like that, and then everybody run to react to this. I think it would be the worst reaction. We have to remain focused on where our interests lie and what is not negotiable, and the non-negotiable is the charter rights of Canadians and the protection and the way the Supreme Court has interpreted the privacy and the limit to transfer information. So it seems to me that we have a pretty, reasonable approach in relation to all this, and I'm not at all ready, as I'm telling you, Mrs. Zwick, to barter anything in relation to, a settlement mechanism.
Merci, Sénateur Joyal. J'espère que l'équipe de négociation de l'ALENA nous écoute et entend vos commentaires pour la négociation. Vous seriez un très bon membre de l'équipe de négociation. Quant à vos questions, je vais d'abord demander à Mme Zwick d'y répondre avant d'aller...
Yes, I certainly understand that perception. And as I was saying to the other honourable senator, to unwind NAFTA in either country is going to take time. This is not, if there is if Trade Promotion Authority fails, because remember, the other part of the question is that the President is acting under the Expedited Trade Promotion Authority, which means that even if he wanted a new deal, he has to do certain things by certain dates and notify Congress so that Congress is completely involved in this renegotiation. So there's a lot of things going on. But any unraveling, it's all domestic law. So it's all convoluted, and it's going to take time. And, it's not absolutely clear that the Canada-U.S. Free Trade Agreement pops back into effect. NAFTA, you read it, it superseded the Canada-U.S. Free Trade Deal. But even if you got another bilateral going, I think your approach is very sensible. You know that it's going to take time if NAFTA is not going to be into effect to unwind, and there's going to be all sorts of stuff going on. And Canada, I agree with you. If the silver lining on any of this is that Canada is out there, negotiating and attempting to negotiate other arrangements and diversify its export markets. So I'm in agreement with some of your comments on that. It's going to be a very complicated, convoluted unwind, and that gives people time.
Professor Geist.
Yeah, sure. In response to your first question, I'd start by saying I think you have a show that Netflix can use that $500 million they're talking about investing in. I wish I could be so sanguine as to take the position that at this stage, the Charter of Rights will protect us from some of the e-commerce rules that have implications for privacy. I think the problem is privacy isn't a word that appears necessarily in a data localization provision. The provision basically says that a country can't, or one of the parties cannot establish rules that mandate the retention of data within their own jurisdiction. And the idea is that, especially from a U.S. perspective, they like to have the data stored in the United States. There's large companies that have established large server farms that have efficiencies, and that's where the data gets stored. There may be other reasons, the NSA and others, why they like to see that data in the United States. From a Canadian perspective, it's not a privacy provision if you agree to that provision, although the implications for privacy are very, very significant, because suddenly now a government, and both the British Columbia government and the Nova Scotia government have established these rules for certain kinds of data that requires that information be retained in the jurisdiction. So the concern is, if we agree to this kind of provision, I mean, could it be subject to a charter challenge? Sure, but the fear would be it's not something that says you can't have privacy or that it's under, but the effect of that kind of provision moves us certainly in that direction.
Somebody else? Okay. Well, I do have an intervention from the audience, and then we'll go to Senators Massaquoi and Beauvais. So I have Carla Venton, Food and Consumer Products of Canada, with a question.
Thank you. I'm enjoying this very lively discussion today. I'm from Food and Consumer Products of Canada, representing over 130 companies that make the value-added products that you find on grocery and drugstore shelves, also the top employer in manufacturing in Canada. So it's really interesting, all the discussions today focusing on our neighbors south of the border. There's definitely a lot of unpredictability there, and there's a lot of things that we can't predict or change. And I'm sure coming out of this meeting, there's going to be, breaking news on something related to NAFTA or international trade and investment. I also think it's a distraction. It's a distraction for what the Canadian government does have control over and what the Canadian government can do to attract investment and jobs in this country. What I'm thinking about here is that there are things that we can do here, and I know that Mr. Mussel touched on that concerning regulatory alignment and how important that is, especially for the agriculture and food sector. We know that this Canadian government is extremely committed to regulatory cooperation and alignment with our major trading partners. We know that the Canada-U.S. Regulatory Cooperation Council is extremely important and should be, because these technical barriers to trade are also huge barriers, of course, to us growing our economies. So we see examples in the food industry. I know that Mr. Mussel touched on a few, but for packaged food products, we see a misalignment taking place. We have the federal government promoting, investment in international trade. Meanwhile, we have Health Canada that is looking at introducing policies that are not aligned at all with our NAFTA trading partners. And there's no reason for why, for example, the front of pack options for food products, which will be extremely costly and unprecedented, on why those products, or why the option that Health Canada is putting forward, that they would not consider what our major trading partners are doing. So this is a huge example of misalignment that we see in the food industry. So my question is, what kind of putting NAFTA aside, because there is so much unpredictability and it's a distraction, what do you think the Canadian government can do domestically to attract investment and attract jobs in Canada? Thanks.
Well, that's a general question, but since you're related to the food industry, we'll start with Al Mussel, but then anybody else who wants to get in.
Yeah, thanks, Keller, for the question. Glad you made it an easy question. It's not an easy question, but you raise a good point. We go to all the effort of negotiating trade agreements, putting in place all of the opportunities, and then what do we do to follow them up? So one issue that you have raised is misalignment of the regulatory system with that in some of our trading partner regions. Of course, the regulatory system is a matter of domestic policy, but when we're talking about technical regulations, in many cases, there's no serious disagreements over the science or process, et cetera. And from my experience with it, it does seem like there may be elements of sort of culture within government in which some of these decisions are made on a fragmented basis. We can compare ourselves, for example, with Australia, in which the regulatory system is operated at least for food and farm products, very much aligned with the investment policy and attempting investment in the food industry as well. The other element that you didn't raise, but I think it's very similar is, so for example, here we are a couple of weeks into CETA, and we've been given some very material opportunities, particularly in the red meat sector, to have material export penetration into a market which is, you might as well say, really a new market for us. We don't have a lot of penetration into the European market in beef and pork. But we need to be able to follow up with policy that will facilitate investment that will allow us to take advantage of that. Because I can tell you right now, where we're positioned, we're not going to have much in the way of pork and beef shipments, certainly not much growth in the immediate future, because we just don't have the capacity there to do it, either to meet their specs or just sheer capacity. And that's years ahead of us. But we also need supportive policy that can facilitate that.
Yes.
Well, you asked a general question, so I'm going to give you a philosophical answer. How's that? First of all, we need to bargain better in trade agreements. Let me give you a perfect example, and you touched on beef. Since we signed the Korea Free Trade Deal in January of 2015, heading into negotiations, Korea had a trade surplus over Canada that was significant. Since January of 2015, trade from Korea, imports from Korea to Canada have gone up 50%. Imports from Canada to Korea have gone up 5%. The big winner in the Korea trade deal was supposed to be beef. Within a couple months, they found one cow with mad cow disease in Alberta. We haven't shipped a thing since. So we haven't yet corrected that. Therefore, you need language in agreement that can correct that. And we need language in agreements that allow us to walk away. So number one, we have to bargain better. Number two, if our number one export industry in Canada is auto, and we ship over 100,000 vehicles a year from Korea to Canada, and they celebrated the fact that we took off the 6.1% tariff, why is it that we can't ship cars that we build to Korea, which has one of the most closed markets in the world? Only 2.5% of all vehicles sold in Korea come from offshore. Japanese dump 159,000 vehicles a year in Canada. Yes, we have assembly plants here in Canada, but we ship about 3,000 a year to Japan. So then, when we talk about the general philosophy of how do we create jobs in Canada, I think we need to use our natural resources and raw materials as the foundation for creating a long-term stable economy. I remember back in 1980 as a young activist, and Francis would remember this. I come from de Havilland Aircraft. I'm a sheet metal worker. That's my trade. So we argued that we should be opening up the island airport to fly in commuter jets. Somehow the mechanism to resolve the Ottawa, Toronto, Montreal, Toronto transportation woes. And we argued against that. We argued in favor of that industry and said, why would anybody waste $1 billion to build a rapid train line from Toronto to Ottawa or from Toronto to Montreal? $1 billion back in 1980. $1 billion that'll get me from me to you, right? So that's what happens when you have a short-term vision when it comes to the economy, of which I had back in 1980. So I hear the arguments today about we're going to have to ship our oil, build pipelines, and I'm good with all of that, but I think it should end up in a Canadian refinery. Because the cost today is $8 billion to refurbish, and they're saying it's too much money. That's the same argument that I had in 1980. So if you want long-term stable jobs, you want to have an economy that flourishes for the long term, then you have to take advantage of your strengths, and that's raw materials and natural resources. It drives me nuts that we'll catch fish on the east coast of Canada and ship it to China for processing and canning, when we should be creating those jobs and maintaining them here in the east coast.
Merci beaucoup à vous tous d'être parmi nous ce matin. C'est évidemment très intéressant. Moi, ma question est plutôt économique, macroéconomique. Je ne sais pas qui peut la répondre, mais je vais te donner partie de mon souci. Quand je vois effectivement la motivation et peut-être l'intérêt de Trump, moi, je crois que c'est probable qu'il va mettre fin à l'entente qui existe, l'ANENA, et ainsi que l'FTA comme tel. Et ma lecture de point de la Constitution américaine, c'est pas clair s'il y a besoin de l'approbation du Congress pour mettre fin à l'entente. Il est certain qu'il y a besoin de l'approbation du Congress de créer une nouvelle entente, mais pas nécessairement de la mettre fin. Or, moi, je ne vois aucune entente qui va être discutée entre les deux parties parce que c'est impossible que le Congress arrive à une nouvelle entente. D'abord, quand je regarde le scénario, disons qu'on n'a plus d'entente d'échange commercial avec les Américains, je regarde le fait que 42 de notre PIB, c'est échanges avec un pays. Les autres sont, même l'Europe, c'est peu important. D'abord, ça me soulève des soucis majeurs au point de notre économie et de notre impact. Les études que j'ai lues à cet égard-là montrent que, n'oublie pas que nous autres, c'est 42 mais avec les Américains, l'échange avec nous autres, c'est 8 Les études que j'ai vues, c'est que même si on n'arrive pas d'entente avec les États-Unis, il y a peu de conséquences économiques aux États-Unis. Il y a beaucoup de turbulences, beaucoup de complications, mais ça ne change pas énormément. Oui, on perd peut-être 500 000 emplois au point de vue de côté voiture automobile, mais ça, c'est égal à 2 mois de création d'emplois aux États-Unis. Ce n'est pas un chiffre important. Bon. Mais nous, j'ai l'impression que ça a un impact assez important. Cependant, je comprends que si tu enlèves les attentes de libre-échange des États-Unis, tu vas WTO, le tarif moyen entre les deux pays, c'est de 2,2 On peut faire l'argument 2,2, c'est important, mais pas super important. Dans 2 mois, notre devise a augmenté par plus que 2,2 puis ça arrive continuellement. Alors, c'est-tu vraiment un désastre pour le Canada, comme certains économistes le suggèrent? 2,2 on pense très bien que ça se gère. J'essaie de comprendre tout ça. Mais les économistes prévoient néanmoins presque une récession au Canada si cette entente-là n'est pas mise en place. Mais en même temps, on fait quoi avec ça? J'essaie de mieux comprendre les conséquences économiques au commun des mortels.
Alors, je me tourne vers les panélistes qui sont très prudents dans leur réaction. Qui ose répondre?
Maybe if I could just say one thing. I think you're correct that it's very, there's no legislation in the United States that deals with the unwinding of a trade treaty. And I think that you will, probably the more prevalent view is that congressional approval is required because you can have a treaty, but if it's not implemented, it doesn't mean anything. So I've got all this in the United States. They've got the Implementation Act. The president can't unilaterally go in and repeal the NAFTA implementation legislation. He doesn't have the authority under the Constitution. So on that issue, but it causes confusion because if he terminates, but then the implementation legislation is still there, it gets very, very confusing. And, I think that it's going to be a very convoluted withdrawal process that is going to take a lot of time. And I don't think that the benefits of NAFTA anymore or any trade agreement are just on tariffs. I saw those numbers too about, where would the tariffs go back to, the WTO tariffs or the MFN tariff of 2%. But there's so much more in a trade agreement now. Those are very early trade agreements that were just focused on tariffs. Now there are so many non-tariff rules in a third generational trade agreement that have got nothing to do with tariff bindings that I cannot think that if Canada goes into a recession and then we have the NAFTA will not help
us if we dismantle NAFTA during that process. I think it will make the recession worse, but just because of the uncertainty. You know, I think that, I guess my point on the tariff issue is I don't look at trade agreements as about tariffs anymore, because there's so many other non-tariff issues that are addressed in them. Government contracting. Thank you. Briefly, Mr. Mussel wants to add.
Yes, if I understood your question correctly, I think you were saying, you know, is this really of sufficient magnitude that could cause a recession in the Canadian economy? And should we really be that concerned? And I'll speak from behalf of the ag and food sector, and you know, we know that 2016, approximately half of our output was exported, and our biggest single trading partner is the United States. So there will be certain sectors for which this absolutely, you know, we've had some questions about, you know, well, wait a minute, you know, don't we fall back on the Canada-U.S. trade agreement if NAFTA dissolves in any particular way? Well, yes. The concern there, however, is, you know, if you get into a bilateral trade negotiation with the United States, what types of leverage, you know, is if we fall back on the Canada-U.S. trade agreement, will it be the same agreement as it was in 1989? And I think many of us would think no. Well, we've got the e-commerce and intellectual property and so on that just simply didn't get dealt with because it didn't exist. So it will be the president has said he likes bilaterals. Well, I think he likes bilaterals because he likes the leverage that he can get on other countries. That's why he likes bilaterals. So we need to keep that in mind. Specific sectors will be very significantly impacted. And, you know, I just wrote a few down in which we have a major export trade. You think about the pork industry, the beef industry, the pulse industry in Western Canada, grains and oilseeds in general, frankly, the greenhouse vegetable industry in Lower Mainland BC and Southwestern Ontario. So I think if you deal with specific industry segments, you've got very definitely the prospect for this to be highly recessionary. And then as Brenda just made reference to, you know, there's sort of the magnitude of effect, and then there's the future uncertainty going forward. And you know, thinking about the greenhouse vegetable industry in southwestern Ontario, that is probably already struggling with concerns about labor cost, energy costs, carbon tax. This is an industry that is gravitating toward the Midwest U.S. People are literally up and leaving, and something like this would, I would think, only accelerate that movement because that's where the markets are.
Okay, we've got 7 minutes left, and 2 senators on the list will complete it. And perhaps if Senator Wu and Senator Bovey could ask their questions first, and then I'll come back to the panel for their answers. And I welcome Senator Wu, the new facilitator of the Independent Senators Group. Senator Wu.
Thank you, Chair. I want to ask about the broader threat to the global trading system and ask panelists, some or all, if they think that this attack on NAFTA is a prelude to some actions against WTO, the global trading system. And this is not just some fantasy that I've thought of, because as some of you will know, there is a pathway that Trump has initiated, which is the Section 232 investigation into anti-dumping of steel. We haven't seen the outcome of that investigation, but if they do go ahead with it, we know it will lead to complaints at the WTO, to the dispute settlement panel. And we know that the U.S., by using Section 232, will plead national security. And as a result, that will be the excuse, if you will, or the precipitant for them to withdraw from the WTO. So I want to ask, you know, and that will be the new Smoot-Hawley. Section 232 will be the Smoot-Hawley of 2017. I want to ask if you think that is a possible scenario, and whether you think we should start preparing for that kind of world, much, much more dangerous than this, in a sense, the small peanuts we're talking about here with the end of NAFTA.
Senator Bovey.
Thank you, and thank you for your presentations. I think they've been certainly very eye-opening from my perspective. My question has to do with where with the IP discussions and IT discussions, do you feel Canadian culture is going to stand? We know in the last round that the magazine industry had a huge effect on the discussions and the outcome, and we know that since then there have been issues with artist work going back and forth across the border because people don't understand where it fits. So I'm just interested to know where you think Canadian culture, arts creators are going to stand in these discussions.
On those two questions, maybe we can go around to all four panelists and you can discuss or answer whatever part of them you'd like. Okay, Professor Geist?
Sure. To start, so I'll focus on the culture issue. I was asked earlier about sacrosanct chapters, and culture has traditionally been one of them. I think we have a bit of a hint of where the U.S. may go on culture based on the Trans-Pacific Partnership. And so in the TPP, for the first time, Canada had agreed to a couple of exceptions to our more traditional approach of saying there are no exceptions, culture is off the table. They involve more digital-oriented issues. And so, for example, there's, of course, been a lot of talk about Netflix and online video services and the kinds of provisions that were essentially excluded from the exclusion in the TPP, focused on the ability to assert regulations in that context. So to the extent to which we're having an ongoing debate in Canada about the emergence of these new digital services and its broader implications for Canadian culture, we are likely to face some amount of pressure on these issues. We've already seen the Motion Picture Association in the United States actually argue that a cultural exception is outdated and is unnecessary altogether. But of course, the Canadian government's responded saying that it's going to stand behind the traditional approach. So this represents just yet another one of these issues where, for the moment, we're potentially really at loggerheads, and the worry is, and it's in a sense, culture becomes similar to some of these other issues that I've highlighted. It gets a little bit lost in the shuffle as some of the other issues take priority, and if there is this sense of a desperation for a deal.
Senator Wu, you asked, I thought, a very good observation. Maybe I'll put it that way, that there indeed may be a real risk of the U.S. beginning to disengage from the world trade environment. And shortly after the president was elected, we started to get this narrative of the United States being a victim of trade. And I think as Canadians, many of us were probably pretty surprised by that, because we look at the U.S. as a very competitive a nation. It's obviously an important market, but a real tough competitor. Well, how did these folks get to be victims? And this worry, this, I don't know what you want to call it, nativist tendency that if decisions are going to be made on disputes, they're going to be made in U.S. courts. I mean, I think you immediately went to the logical extent of that, and with the world's largest economy, or at least I think probably today the world's largest economy, out of the WTO, and how could the other WTO members possibly tolerate a member that would not respect its dispute resolution mechanism? Then that's you're exactly correct. It's a far more serious situation than NAFTA, and we should worry about that.
Just in response to Senator Wu, I certainly do agree with you. I think that was my comment about the binding nature of the dispute settlement mechanism. The only reason the WTO works and why it was such a significant development in 1994 is because of the binding dispute settlement mechanism, whereby countries had to comply or they faced retaliation, and there was a compliance process and there was a rule of law. And, it's inch by inch. So by, Trump saying that, we're not going to have binding dispute settlement, it's a precursor. And to what he's got planned on the greater world stage. I mean, that would take a long time, I think, a long time to achieve, and hopefully, he doesn't get reelected. But that is exactly why I made the comments today about the binational settlement regime.
Final word.
Well, as a owner of a fax machine, I think I'll keep out of the cultural digital era discussion. It's not my forte. But on the question from Senator Wu, look, I'm deeply concerned. I'm deeply concerned about, frankly, where the world is heading as it relates to protectionist issues. And I'm concerned by how it's being delivered. Trump was elected by and large on a platform of how the U.S. was left behind in the trade treaties, paraded through the Rust Belts. To a large extent, he struck a nerve with working class people that share his objective, that they were left behind. I agree with Trump on one thing, like one, and that this trade agreement has not been good for workers in the United States. It hasn't been good for workers in Canada. It hasn't been good for workers in Mexico either. And so when you follow Brexit, and the frustrations, it doesn't only bring in frustrations around trade, it brings in frustrations around issues that, you know, are dangerous to society, because it really starts to tweak some of the racist undertones that people feel empowered to talk about today, more free. So it really is about the opening of debates that are dangerous to the world economy, and I will argue to world peace in many regards. So the debate in the United States is ratcheting up on a whole host of areas of which I will argue the frustration that was generated and created has long-term negative ramifications, not only in the United States, but around the rest of the world. If you wouldn't mind me just touching on some of the other issues. You raised the whole issue earlier on, questions about where this thing is going to end up. And it's interesting because are we heading for a recession was the question. And I don't think so, because things are going to find a way to work themselves out. Let me give you the best example. And it's a terrible analogy, but I'm going to give it anyway. The biggest issue we have outstanding right now with the United States is the softwood lumber dispute. But how this is going to come to an ugly head is you take a look at some of the disasters that are unfolding in the United States. There's going to be such an increased requirement for wood to rebuild that the construction building industry is going to say, why in the hell am I going to pay 30% more to rebuild? I believe that the American population will say this is inherently ridiculous. I believe we'll come to a definition of what the hot market is and resolve the issue in the long term. But this is going to come when the mood shifts. And it is currently shifting because we are in dangerous times. And it's going to take level heads in which to get through it. And I believe that's the type of discussion that's starting to unfold. Listen, people are frustrated by ISDS provisions in trade agreements that allow corporations to sue governments, that stop governments from having the ability to make decisions that they believe are in the best interests of their citizens. So there's a lot going on right now, but ultimately we're going to get through it because we're a nation, as I said, rich in natural resources, raw materials, and people need what we have to offer.
Well, thank you very much. That brings us to the end of our time and end of our meeting. And Co-Chair, I think we've learned a lot here today. I think it's been a terrific dialogue, a terrific learning experience, and a lot of things to think about on an issue that is very current before us each and every day. We're going to assemble again in the open caucus on, excuse me, Wednesday, November 8th, in which we're going to, we got another big subject. We're going to talk about the social and economic impacts of artificial intelligence and robotics. So that's Wednesday, November 8th, same time, same meeting. We might invite Jerry Diaz back. I'm sure he'll have something to say about that. Anyway, thank you so much. And a closing comment.
Merci à vous tous et toutes. Et encore une fois, la qualité des questions et l'intérêt des réponses, je pense, valait le déplacement aujourd'hui. Merci aux gens de l'auditoire et rendez-vous le 8 novembre.
Meeting's adjourned.